Good night to anyone joining the program at this time, at the customary 7 p.m. This is just by way of informing that from tonight, the program will actually commence from 7:30 p.m. and will run for 1 hour. So you please stay tuned and please stay tuned. We'll commence the programming from 7:30 p.m. The night program, we have as our guest Dr. Francis Alexis, as convener of the Citizens for Constitution Reform. He wrote to the government of Grenada and to all parliamentarians proposing change, an amendment to the Constitution so as to remove a perceived discriminatory effect against children born outside of Grenada and out of wedlock to Grenadian fathers. Dr. Alexis will be speaking on this proposed amendment tonight. I will be here along with my co-host, Ms. Aisha McLean. So please just bear with us and we'll start the program at 7:30. For those just joining us, I just need to repeat that the program will actually start at 7:30 p.m. From tonight, the program will run from 7:30 p.m. for 1 hour. We have with us tonight Dr. Francis Alexis as a guest, and he will be here discussing with us a proposed amendment to the Constitution of Grenada to remove the discrimination against children born out of wedlock, born outside of Grenada, out of wedlock to Grenadian fathers. The program will start at 7:30. Dr. Alexis will be here, and I will be here along with the co-host, Ms. Aisha McLean.
Video is an episode recap of Legalize from last week. The theme focused on law, power, and small states, with a specific focus on the Caribbean. The episode discussed how the world feels more tense and unpredictable. Big countries are using power, money, military, and pressure more openly. This raises the question for the Caribbean: how do we protect our interests? The big question posed was whether small Caribbean states are left with only three choices: aligning with a major power, staying neutral and careful, or simply waiting out the storm. Key message number one is, don't panic and don't surrender. The region still has options, but the approach must be smarter and more united to achieve success. Key message number two emphasized that Caribbean unity matters. Fragmentation weakens influence, while a coordinated regional voice strengthens bargaining power. Working together is difficult but necessary. We are now reviewing the key messages from the Legalize episode on law, power, and small states, focusing on the Caribbean. Key message number three is to diversify relationships. This means maintaining respectful ties with traditional partners while building stronger links with Latin America and other global partners like India, China, and Africa. A practical idea discussed was regional energy security. The aim is to reduce fuel vulnerability, explore regional supply options, and build resilience against crises like storms or economic shocks. The mood of the discussion changed by highlighting how quickly global events can shift. Concerns were raised about actions that seem to ignore rules and norms, emphasizing that small states must plan for uncertainty. Migration talk covered the potential pressure on the region to accept deportees or relocated migrants. Key questions revolved around capacity, safety and vetting procedures, and ensuring fair regional burden sharing. The closing takeaway is to be strategic, build alliances, protect national and regional interests, and strengthen local capacity and resilience. This video is an episode recap of Legalize from last week. The theme focused on law, power, and small states, with a specific focus on the Caribbean. The episode discussed how the world feels more tense and unpredictable. Big countries are using power, money, military, and pressure more openly. This raises the question for the Caribbean: how do we protect our interests? The big question posed was whether small Caribbean states are left with only three choices: aligning with a major power, staying neutral and careful, or simply waiting out the storm. Key message number one is, don't panic and don't surrender. The region still has options, but the approach must be smarter and more united to achieve success.
You're muted, by the way.
Hello, good night. Welcome to Legalize this first day of February 2026. So tonight we are supposed to have a very interesting topic. However, we ask you just to bear with us a minute. We're having some technical difficulties with our guest, Dr. Alexis. So we ask just bear with us a few minutes while we try to sort this out.
Video is an episode recap of Legalize from last week. The theme focused on law, power, and small states, with a specific focus on the Caribbean. The episode discussed how the world feels more tense and unpredictable. Big countries are using power, money, military, and pressure more openly. This raises the question for the Caribbean: how do we protect our interests? The big question posed was whether small Caribbean states are left with only three choices: aligning with a major power, staying neutral and careful, or simply waiting out the storm. Key message number one is: don't panic and don't surrender. The region still has options, but the approach must be smarter and more united to achieve success. Key message number two emphasized that Caribbean unity matters. Fragmentation weakens influence, while a coordinated
Good night, Dr. Alexis.
Ewart, how are you doing?
I am just doing fine, and we are so happy to have you.
The pleasure is mine.
Yes, good night once again to all the viewers, and thank you for your patience. We have Dr. Alexis here with us. Before we start, though, we just, as usual, want to recognize those sponsoring this program: Gel Professional Solutions, Inc., Gem FM carrying this program on FM radio out of Canada, and also Grenada Technical and Allied Workers. Good night, Dr. Alexis, once again.
Good night, Ewart Layne. How are you?
I am doing fine.
Good.
On the 26th of January, Dr. Francis Alexis, as the convener of Citizens for Constitution Reform, wrote to the Prime Minister, the Attorney General, and subsequently to all members of Parliament, recommended an amendment to the Constitution to eliminate, to remove perceived discrimination against children born outside of Grenada to Grenadian fathers, but born out of wedlock. And this discrimination is with regard to their being able to inherit, as part of their birthright, citizenship of Grenada. Tonight we have Dr. Alexis here with us to explain, first of all, why the need for this constitution reform and for this constitution amendment, proposed amendment, and secondly, whether a referendum is required for this amendment and other matters. Dr. Alexis, several persons have sent to me, including some people sending me messages today, saying that they were of the opinion that this issue of discrimination against children born out of wedlock was resolved decades ago. And they are asking me if a law was not passed before. And if that is so, why is there a need now for this amendment to the Constitution that is being proposed?
First of all, let me say thank you very much, Ewart, for having me on your program. Pleasure is mine. And I extend a warmest 52nd anniversary of Grenada's national independence to all Grenadians at home and abroad participating in this program. Secondly, I pay tribute to you, Ewart Layne, for identifying this need for this reform you just mentioned. It is because of your focused research on the matter that we are here tonight. And you ask, wasn't this addressed before? The Privy Council answered that question in a case brought to our attention by Ms. Camilla Andrew, a member of CCR, a first-class graduate in public law from the Faculty of Law, University of the West Indies, St. Augustine Campus, Trinidad and Tobago. In 1991, yes, the Parliament of Grenada did enact the Status of Children Act, whose mission essentially continues to be the entitlement of persons born out of wedlock to inherit property on the intestacy of the father, where the paternity of the father is recognized formally by the father or established in a court of law. So that the Status of Children Act is dealing with what we refer to in the law as succession, entitlement to inheritance from the father where the person is born out of wedlock. That is what that act dealt with. So that today in Grenada, if a person is the child of a father born out of wedlock, once the paternity of that father is established, accepted, then the person is entitled to inherit. That's inheritance. That's succession. But what we are talking about tonight now is a different issue, namely citizenship. And you would see in that case, which I just referred to, Attorney General and Rolle, R-O-L-L-E. I don't know if you can put it up for us, Ewart. 2023 UKPC 13, brought to our attention by Camilla Andrew. And you will see in that case that the two issues are addressed side by side, namely the recognition of the right to inheritance, succession under the Status of Children Act on the one hand.
Don't interrupt you, but I wonder if you can just focus the camera a bit more so you can be. Yes, I think that's better.
Good.
A bit higher still. A bit more. No, a bit
Will
more.
that do?
A bit more.
Up.
We're done then.
Yeah.
Good.
Will that do?
That will.
Good. So I was saying that the Privy Council in the case Attorney General and Rolle, 2023 UKPC 13, the Privy Council is referring to the two different regimes. The Status of Children Act dealing with inheritance, succession to property. You were in my company, Ewart, when this lady came up to me around about July last year. I never met her before. And she was saying, thanks very much. You have made me a person in the law. I have now inherited from my father. I was born out of wedlock. So she was dealing with that issue.
Yeah.
We're now upping the ante, we're raising the bar now. And we are talking about citizenship. just as the Privy Council was referring to those two different regimes. On the one hand, there is succession to property. That's what the Status of Children Act deals with. But thanks to you, what we are tonight dealing with a higher issue, so to speak, in terms of citizenship. You could call it a higher issue because recognize what is going on in the world today, in the Western Hemisphere. Our neighbors to the north, the Americans, they're talking about deporting third country nationals to different countries in the Caribbean. And if a Grenadian person cannot show under the citizenship issue that he or she is indeed a Grenadian, he or she might have difficulties, so that your initiative could not have come at a more appropriate time. Because this way, we can enable our Grenadian brothers and sisters abroad to establish beyond the shadow of a doubt that he or she is indeed a Grenadian if Parliament passes this act into act, the bill which the CCR has drafted. Thanks to you again, Ewart.
Okay, so the referendum issue, because last year that was a prominent issue. And once again, here CCR proposing a change to the Constitution. Is this one of those changes which you say is not required by, does not require the support of the two-thirds majority in a referendum?
Section 39 of the Constitution of Grenada answers the question, which provisions of the Constitution require referendum approval by the people to be properly passed? Section 39, subsection 5, it says, a bill to alter this section, section 39, or Schedule 1 to the Constitution, so to speak, requires referendum approval. So if you can put up for us, I don't know if you have that facility tonight.
We don't have it here right now, though.
Sorry?
We don't have it available right now.
We don't have it available.
Yes.
If I hold it up onto the screen, would that help?
Let's see.
If I put it up?
No, it doesn't help. But I think it will be all right if you go through it, because we have been through. We're talking about the schedule.
Yes.
Yes.
So we are in Schedule 1. This is what you may call the referendum list, meaning the list of provisions in the Constitution whose alteration requires referendum approval. You had given it a name last time. How did you call it, Ewart?
Master list.
The master list. That is the list showing in a masterful way which provisions of the Constitution require referendum approval for their alteration. And we are talking about Section 100.
Right.
So we are going down the master list, the referendum list, and you will not see Section 100 on that list. Section 100 belongs to Chapter 7, V2I7. In Roman numeral 5 on the list, you see Chapter 6, VI6. In Roman numeral 6, you see Chapter 8. What you do not see is Chapter 7. So whether you look for it in its own style, Section 100, or you look for it in the chapter to which it belongs, Chapter 7, it is not there. Consequently, you can say, without fear of contradiction, that altering Section 100 in the citizenship chapter does not require referendum approval. What then is needed for its alteration? We go back to Section 39, subsection 2 of the Constitution, which tells you that a bill to alter this Constitution, dot, 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 shall not be regarded as being passed by the House of Representatives unless on its final reading in that House, the bill is supported by, and I quote again, the votes of not less than 2/3 of all the members of that House. So we have cleared away any talk about the bill needing referendum approval because it is not on the master list. It is not on the referendum list, either by itself, Section 100, or by reference to the chapter to which it belongs, Chapter 7, V2I7. So we come back to Section 39, subsection 2, and we see the bill will need the votes of not less than 2/3 of all the members of the House. So just to back up a little, the Status of Children Act, which was passed in 1991, deals with inheritance, inheriting from the father. Whereas tonight we are dealing with a different issue of citizenship. And it is just amazing how the Privy Council is addressing the two different regimes, succession on the one hand, and citizenship on the other hand. And all the courts in this case, Attorney General and Rule, are pointing to the two different regimes. The Status of Children Act is dealing with the right of the person to inherit from the father when born out of wedlock on the one hand, and tonight's topic, citizenship. And the Privy Council is reminding us in their judgment that you have to keep the two different concepts separate, the one from the other.
So, if I may, let me just get it clear. You're saying that this bill that we are proposing, a CCR, deals with a section of the Constitution that clearly does not require a referendum in order for it to be validly amended.
Absolutely no doubt about that.
And that
Does
is so
not
because
need
it is
referendum
yes.
approval.
So even what some people raise as a complication with the Oaths Act, with Section 111, there's no such complication, or even possible complication.
It's impossible. IMPOSSIB. Impossible to bring in the interpretation provision of the Constitution because we are dealing with Chapter 7 on citizenship. And it is just simply impossible in law. Of course, somebody could put an argument, but we're talking about a sustainable argument. Yeah. We're talking about an argument with force. Not only with force, we're talking about an argument which on the face of it requires a response. Because Chapter 7 is a chapter entire unto itself. It is dealing only with citizenship. As a matter of fact, when you read the Privy Council judgment in Attorney General and Rule, you will be struck by a certain phenomenon. One, the Privy Council is refusing, in this case, to bring in concepts of human rights. Yes, in paragraph 30, let me get it for you. In paragraph 55.0, the Privy Council does say that Bahamian citizenship is an important and fundamental right. But the expression fundamental right here has nothing to do with human rights, because the provisions in the Bahamian Constitution on citizenship, they are in Chapter 2, whereas the provisions on human rights in the Bahamas are in Chapter 3. So that when the Privy Council uses the reference here to fundamental right, they are using it in the sense that every individual on earth has a right, a fundamental right. You may call it an inalienable right, but you cannot call it a human right to having citizenship. Let me repeat that. When the Privy Council in paragraph 50 talks about citizenship being an important and fundamental right, the Privy Council is not talking about a human right, because citizenship is covered by Chapter 2. Just as how we have Chapter 7 in Grenada, they have Chapter 2, citizenship, whereas human rights in the Bahamas are in an entirely different chapter, namely Chapter 3. There's another reason why the Privy Council is talking about citizenship being a fundamental right. And it is this. The citizenship chapter in the Bahamas is entrenched at the level of there being a need for referendum approval to alter the chapter on citizenship in the Bahamas. Let me repeat that. In the Constitution of the Bahamas, Article 54, paragraph 3, Roman numeral 2, it is specifically spelled out that to alter any provision on citizenship in the Bahamas, a bill in that behalf needs the majority of the electors voting on the bill. And because the citizenship provisions in the Bahamas are entrenched at the level of referendum approval needed, the Privy Council is saying the citizenship provision in the Bahamas is important and a fundamental right. By contrast, here in Grenada, the citizenship chapter, Chapter 7, is not at all entrenched at the level of requiring referendum approval for its alteration. Fundamental difference.
But you wouldn't say that in any way, or would you say that reduces the importance of citizenship for Grenadians as compared with Bahamians?
It doesn't in the least, because the Privy Council is making the point here in the same paragraph 50, where it was being contended in that case that you have to interpret the word, let me make sure I use the exact word. You have to interpret the word father in Act 14, paragraph 1, to mean only a father of a person born in wedlock. This is what the Privy Council said. That approach, confining father to mean father of a person born in wedlock, reflects, and these are not my words, the words of the Privy Council in paragraph 50, reflects values which have long been rejected and constitute, indeed, in the words of the Privy Council, arbitrary and discriminatory consideration when there is no requirement to do so. What the Privy Council is doing here in this case is rejecting out of hand the idea that a person in the Bahamas may inherit citizenship of the Bahamas not through a father when born out of wedlock, only through a father when born in wedlock. And the Privy Council is saying that to confine acquisition of citizenship to a father when born in wedlock, rejecting it out of hand, that argument to confine it that way reflects values which have long been rejected, and instead is an argument which is based on, in the words of the Privy Council, arbitrary and discriminatory. So let's go to the particulars then of the Grenada bill, which CCR on
Yes,
your initiative produced.
Yes, if we can get it up on the screen, but if you can just put it up, please. Yes, now you see it up on the screen, yes.
Yes, if you go all the way down to clause 3.
Yes.
Before we look at what is on the screen, let's just consider what is in the Constitution right now.
Yes.
So if we can put up section 100, subsection 2 of the Constitution, it would be ideal if we could put them up side by side,
Yes.
if that is possible.
Maybe I can just read it if you don't mind.
Please.
It says, any reference in this chapter, being the chapter on citizenship, being chapter 7, to the father of a person shall, in relation to a person born out of wedlock and not legitimated, be construed as a reference to the mother of that person. So I think, Doc, if you can just tell us what we mean by, what is meant by legitimated there.
Legitimated means that the father of a person born out of wedlock goes through a legal process by which the father says to the law of the land, I accept this person as my child. I give it legitimacy. I give the child legitimacy. But what if the father doesn't do that? And what worse if the father is already dead without having done it? The person born out of wedlock is left in midstream. And that is one of the mischiefs which this bill is designed to correct. Because what you just read is saying any reference in the citizenship chapter to the father of a person in relation to a person born out of wedlock and not legitimated shall be construed as a reference to the mother. I call this cross-gendering because here is the Constitution saying, when you see the word father in relation to a person born out of wedlock and not legitimated, strike the word father and construe it as a reference to the mother, so that the father cannot convey citizenship to the person born out of wedlock. That simply is what we are seeking to correct. We are seeking to correct this cross-gendering operation here and say, when you see the word father, leave the word father and construe it as father, whether the person was born in or out of wedlock. And the Privy Council is saying, in its own context here, the Bahamian case, to argue otherwise is to contend for values, I just want to make sure yes, which have long been rejected. And furthermore, to say that read the word father as mother when the person is born out of wedlock is arbitrary and discriminatory. And that's all we are seeking to correct. Mm-hmm. So if you look at what is on the screen, instead of this cross-gendering operation going on in section 100, subsection 2 of the Constitution as it stands now, we are simply asking the Parliament of Grenada bring section 100, subsection 2 into current values, using the word of the Privy Council, and end the discriminatory practice here by saying any reference in this chapter, and this is a chapter on citizenship, chapter 7, to the father of a person shall be construed as including Roman numeral 1, the male parent of a person born in wedlock, and 2, the male parent of a person born out of wedlock if the male parent formally acknowledges his paternity of that person, which is in effect legitimizing the person born out of wedlock, or if the paternity of the male parent of that person born out of wedlock is established in a court of law. And these are exactly, Ewart, the issues being addressed by the Privy Council and the courts in the Bahamas in role, meaning all that is needed is for the male parent to acknowledge paternity, or if that cannot be done for whatever reason, male parent might have died, for example, the paternity of the male parent be established in a court of law, which is what is done under the Status of Children Act. The paternity is established in a court of law. The Privy Council is making some very interesting points in this case. They're saying, for example, to keep citizenship flowing only through the mother would mean that the child of an unmarried Bahamian mother born in the Bahamas would have an entitlement to automatic citizenship, whilst the child of an unmarried father, also born in the Bahamas, whose paternity had been legally established, would have no such entitlement. I want to stay on this point. I want to stay on this point because I've seen somebody suggesting that all you need to do in Grenada is pass an ordinary act, don't amend the Constitution, and give the person born out of wedlock citizenship.
So Doc, I actually wanted to take you to that point too. But before we go to that point, I just wanted to just get from you. The practice is normally, in terms of accepting paternity, you agree and you have your name placed on the birth certificate of the child in the column father of the child.
Yes.
Right? And I know the practices in terms of legitimating, certainly before the 1991 Act, and even after, what is required there is, I don't think acceptance is sufficient. What is required there is that the father must actually get married to the mother. So you have the child out of wedlock, and then subsequently you get married to the mother. I think that is how they treated the legitimated issue. So, as somebody was pointing out to me yesterday, you can have a Grenadian father, let's say in North America. He has 2 children, right? He has 2 children before he is married, but with different mothers. But he decided to get married to the mother of one of them. That child will be entitled as part of their birthright to Grenadian citizenship. But the other child is also the father, he recognizes himself as the father, will not be treated in the same way. You know, and the person was pointing this out to me and just making the point how absurd this situation has been and continues to be. But I want to also ask you, Doctor, you use the term woeful. I think in your letter to the Prime Minister and to the AG and so, let me see the exact reference. You use the term, you describe it as a woeful injustice, that a child should be treated differently simply because no fault of the child was born out of wedlock. I know you have been very passionate over the decades on this issue in terms of the right of children. So I just don't know if you just want to comment on it on the use of that term in this context?
I used that term before I read this Privy Council decision brought to attention by Kamala Andrew.
Mm.
And Privy Council is using even stronger terms here in paragraph 50, because they are referring to that situation as arbitrary and discriminatory.
Mm-hmm.
I use the word woeful without, at the time, having the benefit of the Privy Council decision. If you say, I use the word woeful, the Privy Council is using stronger terms here. Mm-hmm. They're saying it's not just woeful, it's arbitrary and it's discriminatory. And it reflects, they say, and I agree, values which have long been rejected. Mm-hmm. So we are in a situation where even the Privy Council is using stronger terms than what I use in the letter to the Prime Minister, to the Attorney General, to the leader of the opposition, and the leader of the People's Democratic Movement. And while I'm about it, let me correct, we haven't yet reached all the members of Parliament. We thought we would start with, so to speak, the leaders in Parliament, and they would filter down to their colleagues. But this week, we intend to reach all. We have contacted the Parliament office and asked for the email addresses of all parliamentarians. And as in the past, naturally, we'll be fanning out across the country, going onto the radio and the TV stations to reach everybody as far as possible. So what the Privy Council is saying in this case is that to deny citizenship to a person born out of wedlock and grant it to a person born in wedlock is discriminatory, which is what we are saying in our submissions to the authorities. I don't know if you will allow me now to take the point which I was going on to, or if you still want to reserve it.
Yes, I want to, because maybe I may introduce it by saying that under Section 99, or you want to deal with it now, the Parliament has the power to make provision for acquisition of Grenadian citizenship by persons who are not eligible or no longer eligible to become citizens of Grenada under the provision of this chapter. So I think the argument is that why go and tinker with the Constitution if Parliament by ordinary law can make provision for children born out of wedlock, outside of Grenada, to a father who is born in Grenada? Why not just simply pass a law to remedy that situation rather than go to the Constitution?
That solution is even more discriminatory than what prevails now. Let me explain why I say that. So you're going to have two dispensations, one for children born in wedlock, and they are deriving their citizenship directly from the Constitution. But you're going to consign persons born out of wedlock to an ordinary act of Parliament from which they would get their Grenadian citizenship. I'm telling you that that is even more unfortunate than what prevails now because of this. When the Constitution of Grenada was being prepared in 1973, I have the document here. Again, thanks to you, Ewart, because last year you made this document available to us. It is the report of the Grenada Constitutional Conference held in Marlborough House, London, May 1973. You go through that report, you will see that no attention was paid to this issue we're dealing with, namely citizenship for persons born out of wedlock. It was not addressed specifically, I mean. It was not addressed in the report at all. So that one could understand that in the Independence Constitution, in Chapter 7, what happened was that there was a perpetuation of the old-time approach to citizenship and birth out of wedlock, which the Privy Council is addressing to in this Bahamian case, talking about the common law tended to treat child as child born in wedlock. That was a common approach. No attention was paid to it specifically. And you could see the Privy Council referring to that in this case here. But here we are in 2026. A few days away from our 52nd anniversary of independence. And we are specifically addressing it now. And somebody is going to suggest, in this day and age, it would be proper for persons born out of wedlock to get their citizenship from an ordinary act of Parliament, while persons born in wedlock are getting their citizenship from the Constitution directly. You just have to mention it to see how unfortunate that submission is. Not only does it perpetuate discrimination against persons born out of wedlock, but it is doing so in 2026 when the Privy Council is making the point that you can't have two different systems going down the road. All must get their citizenship directly from the Constitution. And that is the point we are making.
But what's the practical?
Sorry.
What will be the practical difference now?
The practical difference will be that persons born out of wedlock would be turning to an ordinary act of Parliament for their citizenship, whereas persons born in wedlock would be locking in directly to the Constitution for their citizenship. It really is absurd.
So those born within wedlock, it will be part of their birthright. Am I correct in saying that?
Yes, it's part of the birthright. In fact, the person who put the proposal recognizes a certain other problem, namely, those born in wedlock, they don't have to apply for citizenship. Where that proposal entails that persons born out of wedlock would have to apply for citizenship. You just have to read to see how
and then also
it is.
I think section 99(2) itself says that Parliament may make provision for depriving of its citizenship of Grenada any person who is a citizen of Grenada, otherwise done by virtue of 94, 96, and in this case 97. So, in other words, someone who gets it under a law passed by Parliament, we say that it can be deprived of it. They may be deprived of it, while someone for whom it is part of their birthright under 97, you cannot deprive them of it. Am I correct in saying that, Doc?
You could put it that way, yes. It at
So
the very least raised that
in
issue.
practical terms now, let me ask you, given what is happening in the world now, someone who is a Grenadian, let's say in North America, born in North America, born in the US, for example, to a Grenadian father, that father having been born in Grenada and therefore a citizen of Grenada. But if the person is born out of wedlock, as the law is currently now, if, for example, the United States decides to deport them, they do not have a right to return to Grenada, to say, I'm coming back to Grenada. They don't have that absolute right. Am I correct?
I'm not sure, but what I'm sure of is that if you have two categories of citizens, one born in wedlock, getting their citizenship at birth directly from the Constitution, but you have another category now, getting their citizenship not directly from the Constitution, but from an act passed by Parliament. You are opening up yourself to saying that you have first-class citizens and second-class citizens.
Yeah.
First-class citizens are getting their citizenship directly from the Constitution itself, but the second-class citizens born out of wedlock are getting their citizenship not directly from the Constitution, but from an act passed ordinarily by Parliament.
And that act could be provision to deprive them of it.
Remember, this bill we are talking about is a bill which will fit into the Constitution. It will become part of the Constitution. It is amending the Constitution. Whereas this idea that you can pass an ordinary act, that does not go into the Constitution. It is the horse day outside of the Constitution. And the more I think about it, the more I have to say that that proposal is open. It is contemplating two categories of Grenadian citizenship in relation to both out of marriage or in marriage. First class citizens and second
there's a
class.
question here. There's a question here for you from Dave Ned. And his question is, what are the specific values that Dr. Alexis is referring to in Chapter 7 of the Constitution that are, in quotation, long gone? I think that's the words of the critical.
That are what, sorry? Oh, long gone.
Long gone.
Yes. Discriminating against a person because the person is born out of marriage, that's a value long gone.
And the Privy Council
We have
said that is wrong.
accepted it in our Status of Children Act.
Yeah.
What could be more heinous than that? Discriminating against a person, not because the person has done anything wrong, but simply because the person is born out of marriage. You're a second-class citizen.
Yeah.
That is what it is. Discriminating against a person, not because the person has said anything wrong, but because of the accident of birth out of marriage. I've given you 3 examples. The Council didn't even bother to condescend to these details, but I have given you 3 examples of values long gone.
And Cyrus Griffith is asking, has the CCJ dealt with a matter like that before? And if yes, what was the decision?
Hi, Cyrus Griffith, how are you doing? I didn't mean not hi to the evening. Hi to all of you.
Yes.
I don't know. I honestly don't know whether the CCJ has addressed that issue. I didn't even know that the Privy Council had addressed this issue until last week. Was it last week?
Yes, it
When,
was last.
when our
And-
member at Hugh Wooding Law School
Yes, a young lady at Woodland Law School drew it to our attention, drew this
drew
case
it
to
to
our
our attention. So I'm afraid, no, I don't know whether the CCJ has addressed that issue yet. Sorry.
So if I may ask, Doc, I don't know if you have reviewed the other constitutions in the OECS and the Caribbean. If I may ask, what's the general position with regard to this matter?
I have not specifically looked at that, but I have looked at the Bahamian Constitution in the context of this case here. And the issue arising in the Bahamian case shows us that what I indicated earlier just now, in the drafting of the Grenadian Constitution in 1973, those constitutions were prepared at a time when those values, long out of currency, were very much still in currency, discriminating against children born out of wedlock. It will therefore come to us as no surprise that specifically what the Privy Council is addressing in the Bahamian case and what we are addressing in this bill which we have prepared in CCR, you will find them reflected, especially in the Jamaican Constitution. I say especially because in this respect, the Jamaican Constitution has not yet been revised. The Trinidadian Constitution has been replaced, but I can't say that in relation to the specific issue we are addressing now, whether that was looked at. But my thesis is, given the line relating to the drafting of all those constitutions, including Grenada's, and don't forget the Bahamian Constitution would have been about, I think about 1973 or so too.
73.
You will not be surprised to find in the citizenship provisions what the Privy Council is now referring to as those values which have long been rejected, namely discriminating against a person purely because the person was born out of wedlock, discriminating against a person not because of anything the person has done, discriminating against a person not because of anything the person has said. Those are the values which I think the Privy Council is talking about, because the Privy Council did not bother to detail them.
Yeah. I think for my own research, Doc, and of course I'm subject to correction, I think St. Vincent, St. Lucia, Dominica, St. Kitts have all gone beyond that. So I don't think their constitution have that problem. Antigua, they have something as ours, but I don't know, it's doubtful. If it comes to interpretation, how it would be interpreted. But think St. Vincent, St. Lucia, St. Kitts is probably the strongest because they have outlawed for all purposes discrimination against anyone just on the basis of being born out of wedlock. But let me ask you, Doc, just a follow-up. Based on your experience from 1991, because you were in the forefront, in the trenches on that issue that came to fruition in 1991, did you experience much opposition to your strong advocacy for the view that a child must be treated as a child and a child should not be saddled with discrimination for reasons of being born out of wedlock, something they had nothing to do? Talking about in 1989, 1991, what was your experience then? The follow-up question will be if you expect any such pushback, if there was pushback in 91, if you expect any such pushback actually 35 years later.
There was a lot of difficulty. I personally had to go around the country. I had consultations with groups, church groups. I remember one here in particular in Heinz's school, and that was pretty vitriolic. I stood my ground. Some people were being afraid that if you push this reform, you're going to undo the institution of marriage. And that is why you will see, Ewart, that a companion piece to the Status of Children Act was a reform to the inheritance law. Because what I said was very well. If it is that the wives are afraid that they would get less from the husbands on death, we would amend the inheritance law. Because under the old inheritance law, when the husband died, the wife succeeding alive would get only 1/3 of the property, and the children would get 2/3. So a quid pro quo was very well, we would amend the inheritance law so that the spouse surviving would get not only 1/3 in future, but would now get 1/2. And the remaining half would be divided among the children. So if you read those two acts together, you would see a lot of sociology there.
Mm-hmm.
When we came up with that changing of the inheritance law, I am happy to tell you a lot of the opposition dissipated. Because that reform to the inheritance law told the people of Grenada, no, we're not about trying to deny the surviving wife a rightful share. I don't know if you ever observed that before, but go back tonight and you see that the inheritance law was changed the same time to all affairs. I was lucky, I must tell you, that I had a very progressive prime minister in Nicholas Bradford. And he gave full support to the Status of Children Act. Full support in and out of Parliament. He never, ever vacillated. But to answer your question and to show you how strong was the resistance, we had to come up with a reassurance to the people that passing this act is not going to undo surviving spouses. And that is how we had to change the inheritance law to move it from 1/3 to 1/2. Let me tell you this furthermore, as you asked the question. There was some suggestion that there was going to be a companion act to say that if a woman lived with a man under the same roof for a number of years, say about 7 years, she should be entitled to inherit as if she were a lawful wife. Legislation like that had already been passed in Barbados, in Trinidad and Tobago. And we have to give assurances that we were not going to come with that kind of legislation out now in 1991. We still, I'm afraid, don't have it. So then, your follow-up question is, do I anticipate that sort of problems? I don't, not this time. Grenada has moved far ahead of that backward situation. And when I say backward situation, I have the authority of the Privy Council, because they are talking about values which have long been rejected. I have the authority of the Privy Council to speak like that, because they are talking about arbitrary and discriminatory practices against children born out of wedlock. And people have seen since 1991 that Grenada is not disappearing under the Caribbean Sea to treat people born out of wedlock in a rightful and just manner. The country is not disappearing. We're not eating one another. So we have the advantage then of that experience. We also have the advantage that from last year, when you change the constitution you're not going to rip up. And we're going to start fighting one another. We have that advantage too. So I don't anticipate any such pushback. Because even the person who was suggested, give it to them in an act and not in the constitution. Even that person is confessing that she recognizes that there are some inelegancies about it, but she's just putting it out for what it is worth. And sorry, it isn't worth anything.
Yes, so Doc, we really want to thank you for appearing and being so eloquent in explaining this proposed amendment to Grenadians, the contents of it, the purpose of it, the context of it. And before I invite you to give closing remarks, I just want to do two things. I apologize for the absence of the co-host. She communicated just before we came on to say that something came up urgently, and she apologized for not being here.
I miss that, yes.
Yes, Ms. McLean. Yeah, and secondly, I just want to once again recognize the sponsors of this program, Jim Professor Sushase, Jim FM carried the program on FM radio out in Canada, also Grenadian Technical Airline. I see Dave Nell has posted something here. Since subsection 2 of section 100 specifically refers to a person born out of wedlock and not legitimated. This is specific consideration in that birth was not legitimated in that circumstance, i.e. that the birth was not made legitimate. Then and only then would reference to the father be construed as mother of that person. What is legitimate birth? Is discrimination considered an aspirational value? So, Doc, I just invite you to give closing comments. If you wish, you can comment.
I have several closing comments. First,
Yes.
it is always good to have Dave Neda and his group around. They serve the value of bringing out the best in us. They serve the value of forcing us to see the other side, and we welcome that. So it's good having you, Dave Ned, you and your group. We look forward to having us sit down with you and your group to explain further what is going on here. Secondly, we have absolutely no doubt whatsoever, and when Dave Ned forced us last year to talk about it, we can say without shadow of a doubt, no referendum is needed for this change. Chapter 7 is not on the master list. Section 100 is not on the master list. I don't think anybody is going to suggest otherwise, with a serious face, that is. Thirdly, the fact that CCR and the DaveNet group are doing their work is evidenced by the circumstance that here we are on the eve of the 52nd anniversary of national independence, engaging in further discussion on the matter of reform of the Constitution. I want to pay tribute to Kamala Andrew, who is at the Hewarding Law School, because were it not for her, I would have come here tonight just arguing from first principles. But thanks to her, we're not just arguing from first principles, we argue from the depths of the highest authority, legal authority over Grenada. And I would recommend this reading. The name of the case is Attorney General and Role, ROWLE. The reference is 2023 UKPC 13. All we are seeking to do is simply to put Grenadians born out of wedlock on the same footing as Grenadians born in wedlock in relation to citizenship. What we did in 1991 had to do with inheritance and succession. Tonight we are talking about citizenship. And it is interesting because they are talking about the Status of Children Act in the Bahamas and making the point that the Status of Children Act in the Bahamas specifically said it was not dealing with citizenship. Thank God. Our Status of Children Act in Grenada says nothing about citizenship. It doesn't say it's not dealing with citizenship. We didn't have to make that concession in 1991. All we had to do was to change the inheritance law. Finally, I saved the best for last. I'm paying tribute to you, Ewart Layne, because this is your brainchild. We in CCR are simply tagging along with you because we see the undeniable nobility in your initiative, and we are going full speed ahead with your project. Thank you very much. And with that,
Well, I wanted to be recorded that you are the father of this movement for bringing justice to children irrespective of the circumstances of their birth. And this is something that I think is noble and honorable, and we are just really following on the work that you did in 1991. And as I say, I was in your presence when I saw this elderly lady come up to you. And I was quite touched by what she said. Because that time we were discussing the oaths. So I thought she was coming to talk to you about the oaths. But no, she was talking about something over 30 years ago. When she said, thanks to you, I became a person. My father had me out of wedlock, but I was able to inherit. I think that's a real fitting contribution. I want to end on this note. Thank you, everyone, for viewing this program tonight. Thank you, Doc, for your appearance. We will see you next week. Thank you, Doc. Thank you, viewers. Thank you, everyone.
Thanks to all who are on the program.
Background. So, let's thank you to the sponsor. Bye.